The principle of no punishment without law is not limited to prohibiting the prosecution and punishment for conduct that is not explicitly defined as an offence. To ensure an effective safeguard against arbitrary prosecution, conviction and punishment, laws imposing criminal penalties must be drafted in a manner that provides fair notice of what conduct is prohibited. The practice of the United Nations Human Rights Committee, the case law of the European Court of Human Rights, international criminal tribunals and other international jurisdictions, as well as domestic courts in many countries, highlight several essential requirements derived from this principle. As the European Court of Human Rights explained in a series of cases interpreting Article 7 of the European Convention on Human Rights, which closely aligns with Article 15 of the International Covenant on Civil and Political Rights. So to truly grasp the importance of Article 7, no punishment without law, it's essential to delve into its historical context and evolution. This principle has deep roots, tracing back to the Enlightenment era, where thinkers like Montesquieu and Beccaria emphasized the need for laws to be clear and just. The horrors of arbitrary punishment during regimes like the French Revolution's reign of terror only reinforced the necessity for such a principle. Fast forward to the 20th century, the aftermath of World War II and the Nuremberg trials highlighted the critical importance of having clear legal standards to prevent abuses of power. These trials set precedents, illustrating that crimes must be precisely defined by law, ensuring individuals understand what constitutes criminal behavior. This principle was further cemented in modern legal frameworks, including the European Convention on Human Rights and the International Covenant on Civil and Political Rights. It serves as a bulwark against retroactive criminal laws and arbitrary prosecutions, ensuring justice is fairly administered. Understanding this historical backdrop enriches our appreciation of Article 7's role in safeguarding human rights and upholding the rule of law in contemporary legal systems. So, Article 7. No punishment without law embodies, more generally, the principle that only the law can define a crime and prescribe a penalty. Criminal law must not be extensively construed to the detriment of an accused, for instance, by analogy. In other words, while in civil and administrative law it is generally permissible to apply a rule to situations that are analogous or similar to those explicitly covered by a legal provision, this is not generally allowed in criminal law. So, the concept of law implies qualitative requirements, including those of accessibility and foreseeability. This means that offences and their corresponding penalties must be clearly defined in law. This requirement is fulfilled when an individual can determine, from the wording of the relevant legal provision, and if necessary with the assistance of judicial interpretation or appropriate legal advice, to a reasonable degree under the circumstances, what actions or omissions will render them criminally liable. To better understand how accessibility and foreseeability play out in the real world, let's examine a recent landmark case. In 2018, the European Court of Human Rights heard the case of Del Rio Prada versus Spain. This case revolved around the retroactive application of legal changes that affected the duration of the applicant's prison sentence. Originally sentenced under one set of legal provisions, the applicant found herself subject to a new law that extended her sentence. She argued that this new law was neither accessible nor foreseeable at the time of her original sentencing. The court agreed. It emphasized that any law affecting a person's liberty must be both accessible and foreseeable. The applicant could not have anticipated the changes that were made to her sentence, and thus the retroactive application violated Article 7 of the ECHR. This case underscores the essential nature of these principles in protecting individuals from arbitrary and unexpected legal consequences. It highlights the responsibility of states to ensure that their laws are clear, published, and stable enough for individuals to understand the legal ramifications of their actions. As we move forward, it becomes evident that the principles of accessibility and foreseeability are not just theoretical constructs, but practical necessities that uphold the rule of law and protect human rights. Now, let's explore how these principles are applied within the complex and often controversial realm of counter-terrorism laws. Before we delve into the application of accessibility and foreseeability in counter-terrorism laws, let's take a closer look at a case study that highlights the challenges and adaptations necessary in the legislative process. Consider the situation in the United Kingdom with the Investigatory Powers Act 2016, often referred to as the Snoopers Charter. This act expanded the surveillance capabilities of the government, raising significant concerns about privacy and civil liberties. The legislation was introduced to replace a series of outdated laws and to provide a comprehensive framework for surveillance activities. However, critics argued that the law lacked clarity and transparency, making it difficult for individuals to foresee how it might be applied to them. The UK government faced significant legal challenges, with various human rights organisations arguing that the law violated the principles of accessibility and foreseeability as enshrined in Article 7 of the ECHR. In response, the government made several amendments to the Act, aiming to better define the scope and limitations of surveillance powers. These changes included clearer guidelines on the use of data and more robust oversight mechanisms. This case study illustrates the delicate balance that must be struck between national security interests and the protection of individual rights. It also underscores the importance of legislative clarity and transparency in ensuring that laws are accessible and foreseeable to those they govern. With this understanding, we can now turn our attention to how international legal instruments in the realm of counterterrorism strive to meet these essential principles. The universal counterterrorism legal instruments negotiated within the framework of the United Nations, the International Civil Aviation Organization, the International Maritime Organization, and the International Atomic Energy Agency provide detailed definitions of terrorist offenses that comply with the requirements of accessibility and foreseeability of criminal law. States parties to these instruments commit to incorporating those offences into their domestic criminal law, though not necessarily by taking over word by word the definition of the offence in the international treaty.